Hi everyone, my name is Beth Brown and I am counsel in the Pensions Group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. Time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Hi everyone and welcome to this episode. This month we will be talking about the Pensions Regulator's guidance on protecting schemes from employer distress. So I thought it'd be helpful to get my colleague Nicola Collins, who is a senior associate in our restructuring team, along to talk about distressed employer situations.
Hi everybody.
Hi Nicola. So the regulator has produced guidance for trustees of defined benefit schemes on remaining alert, planning and preparing, particularly in light of the fact that COVID-19 continues to have a profound economic impact on sponsoring employers. It also serves as a helpful reminder of the regulator's principles of good practice, with some practical examples when future-proofing pension schemes against the sponsoring employer's distress. Nicola, can you talk to us a little bit about what we mean when we talk about a sponsoring employer's distress?
No problem, Beth. So what is actually meant by the term distress in this context? Well, one way to look at this is to imagine the life cycle of a business as a curve from growth to recovery, step one being growth. This might then move into step two, underperformance for whatever reason. But if no remedial action is taken when a company is underperforming, then the company can quite quickly slip into distress, which is step three. Some refer to this as the zone of insolvency. However, it is important to remember that this is a distress situation and not yet a crisis, which would be step four. So when a business is in distress, it's far from certain that they are bound to fail or indeed bound to enter any formal insolvency process. But it is at this point that the owners of the sponsoring employer need to act to restructure or resolve potential problems if they have not done so already. Once in a distressed situation, it is likely that an external party will be required for the business to survive and kind of get back to performing as it should. But there are some general signs of distress to watch out for. So these are things such as cash flow, defaulting on payments, extended debtor or creditor days, and falling margins.
Great, thanks Nicola. That's really helpful to set the context. So now we've set the scene, we can look at in more detail at the regulator's guidance. The guidance emphasises the regulator's expectations that trustees adopt risk-based principles on an ongoing basis to identify risks earlier and enable them to act sooner. Trustees need to be mindful of the fact that they are the ones that are the first line of defence for savers, and they need to protect their position. The guidance urges trustees to do the following. 1. Review their integrated risk management and governance procedures and keep them under regular review. The integrated risk management should be fully and clearly documented with workable contingency plans and specific trigger points. For example, trustees should not wait for formal confirmation of a covenant downgrade at an actuarial valuation. Ideally, these contingency plans should be legally enforceable where that's possible. Trustees should have trigger points which could be warning signs such as the loss of key customer contracts, irregular timing of payments, information not being freely shared, or significant changes to the trustee board. 2. Trustees should understand the legal obligations of the employer of the scheme and the possible outcomes for the scheme in a hypothetical insolvency. This will really help when assessing the scale of risk and, if relevant, any proposed mitigation. Trustees should be familiar with the scheme trust deed and rules and any other legally binding documents. It's imperative that trustees understand what powers and protections they have under scheme governing documentation. 3. Trustees should consider the scheme governance and any potential conflicts of interest which will need to be managed, particularly for those holding senior roles within the sponsoring employer. Again, thinking about this now and having that contingency plan in place will be helpful if a sponsoring employer later goes into insolvency. This won't be new to any of us, but the guidance also suggests that trustees should continuously review the skills and expertise on the board, and where there are gaps in knowledge, consider training or further appointments to ensure that the board is well equipped to deal with unfolding scenarios which will often be time sensitive. The guidance also talks about engaging with the sponsoring employer. Nicola, do you want to talk about that a little bit?
Yes, of course, Beth. So the guidance says that trustees should engage regularly with the sponsoring employer to identify key risks early on. Agreeing an information sharing protocol up front will always be beneficial for times of distress. And the guidance notes that the pension scheme is generally one of the largest creditors of the employer, and so should be treated as such. Open dialogue with the employer is encouraged, but trustees should be able to demonstrate why information is sought. Now, the further along the distress curve, the more frequent the employer's cash flow forecasts should be anyway, and so the trustees should ask for sight of such forecasts. The regulator suggests seeking to align information requests and to understand the information which is actually being produced by management. So what is the position of the other creditors? What is the capital structure of the sponsoring employer? What is the intercompany trading and financing position? And when are the debt maturities? Their second point is to monitor the covenant on an ongoing basis, review and challenge financial forecasts and stress test the assumptions. And the trustees are urged to consider the impact forecasts will have on banking covenants and when scenarios might result in a covenant downgrade, for example. So the frequency of covenant monitoring should reflect any heightened risk profile. And when heightened, the focus should move from long-term forecasts to short-term financial information. When an employer shows signs of distress, trustees should review the scheme's key risk areas to make sure these still satisfy the overall scheme objective. Trustees should also understand the potential returns to the scheme in a theoretical insolvency. Now, the third point being to act before a sponsoring employer shows signs of distress and not to delay in putting robust scheme protections in place. Things like forecast banking covenant defaults may lead to lenders reducing their undrawn cash or credit from a banking facility. They may also, for example, seek security or to increase schedules of repayment of debt. So any delay by the trustees at this stage may mean that lenders and other stakeholders are in a better position to exert control over the sponsoring employer and extract value, potentially to the detriment of the scheme. And finally, to communicate with and support members. So trustees are already expected to have well-established channels of communication with members. However, in times of distress, the regulator encourages trustees to ensure members are updated and actually understand the protections in place. Consider preparing a communication strategy now and to provide education around potential scams linked to statutory transfers, which may be more common when members are concerned about a sponsoring employer in times of sponsor distress.
Thanks, Nicola. I would just add to that in essence, in the current economic climate, the regulator is encouraging all trustees to take action, understand their legal obligations, and seek appropriate advice where relevant. The guidance recognises that paying for advice at a time of financial distress may feel a little bit uncomfortable, but trustees really do need that good understanding of their options to protect the scheme and its members. Specialist advice is particularly important when a sponsoring employer has complex financial arrangements involving other parties, and the trustee needs to be able to understand the scheme's position in relation to other creditors. So turning to investment risk next, given an employer's insolvency can crystallise short-term investment losses, trustees should consider the value at risk and what level of investment is supportable. Essentially, the weaker the employer covenant, the less investment risk trustees will normally be expected to take. And if it looks likely that a sponsoring employer is going to fail and a scheme is going to be wound up, the trustees will probably want to start thinking about adopting an investment strategy geared towards buyout. Therefore, trustees should consider implementing a contingency plan. They may want to think about reviewing the investment governance to ensure trustees can react quickly to what is commonly a changing situation, understanding any additional asset classes and preparing for the hiring of any new investment managers, and deciding on the de-risk asset allocation, which should be targeted, including the level of interest rate and inflation hedging associated with such strategy. These are obviously proactive actions that trustees can take, but sometimes the trustees will find themselves having to take more reactive actions as well. In particular, in distress scenarios, it's common for a sponsoring employer to approach trustees and seek various easements. I'm going to hand back over to Nicola now to talk a bit more about that.
So the first point, scheme easements in distressed scenarios. A sponsoring employer may seek various easements from the scheme when in distress. This may include things such as a request to defer deficit repair contributions or to release security held over assets. Now, a request for the release of security may be to facilitate the employer selling certain assets or obtaining funding. However, the regulator recognises that it is very unlikely that security release will be in the members' best interests. So any decision of this nature should be made with the benefit of specialist legal and financial advice. As I said, the regulator expects trustees to regularly engage with their sponsoring employer, but particularly when being requested for various easements, so that they can obtain as much information as possible about the easement sought and enable the trustees to ensure that the scheme is being treated fairly and that any burden is being shared proportionately with other creditors and stakeholders. Trustees need to consider the scheme's position if any easement is to be granted, and whether the sponsoring employer is more likely to be able to continue as a result, as against the scheme's position if the company goes insolvent now. The guidance also suggests that trustees consider whether it is appropriate to call a valuation, to use contribution powers, or to enact or reset contingency plans already in place. The separate point relates to corporate activity. Now, corporate activity we're referring to here is such as refinancing or restructuring, which might cause material detriment to the pension scheme. So it's really important for trustees to understand what is being contemplated, why this is being contemplated, and what impact this will have on the scheme. If a trustee considers that a transaction will cause or has already caused material detriment, then the trustees should seek mitigation, albeit this may be limited in a distressed situation. Now, if a sponsoring employer insolvency is looking likely, specialist advice should be taken to consider all options available to protect the scheme's position, which may include enforcement.
It's also worth noting that the guidance reminds trustees of their reporting obligations in certain scenarios and the practical steps to be taken to prepare for a pension protection fund or PPF assessment, such as, from a practical perspective, putting in place contingency plans for documents and data held on company premises, and making sure that there is actually a complete set of governing documents held. Reviewing steps to realise charges and assets contingent on the employer's failure. Putting in place contingency plans for payroll and banking independent of the employer, so that could continue if the employer is in distress. And reviewing employers for PPF entry purposes. We've just finished by saying that the guidance from the regulator is a timely reminder that in the current climate, trustees should be taking active steps to plan ahead, review their legal position, and prepare for all eventualities. So just to end on a less distressed employer note, I know there's not really much that people can be doing in lockdown, and people that have listened to my podcast before know that I've been asking about books and TV shows, but hopefully we will be out of lockdown or tier system in the next few months, definitely by Easter. So it's time to start thinking about holidays and things. And Nicola, have you got any recommendations of places that you've visited or would like to go to again?
Well, it's nice to cast our mind back to happier and more free times. But I suppose, thinking of treks, this time last year I was actually still in Patagonia, away in the fresh air and the beautiful countryside of South America in the mountains. So that would be my recommendation, as soon as we can and if able, to start planning a trip.
Excellent. So when we can start booking our trips again, bear that in mind. So that concludes this episode, and all that is left to do is to say thank you to Nicola. So thanks, Nicola, for joining.
Thanks, Beth.
Please do feel free to email me or Nicola with any comments or questions on this episode. This episode is an overview of the law and guidance in this area, and how the law and guidance will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances. Thank you for listening.